that for you, just let me know. And if you don't, I'll probably say you. So we're ready to start. White versus State.
Good morning. May it please the Court. I'm John Sheldon, and I represent Mike White, pro bono and pro hoc teacher. Rick Giglio was with me sponsoring me, Jack Gordon from Maine, Gordon and Sellers, and thank them. I would like to reserve 5 minutes.
Okay.
Mike White was convicted of robbery while wearing a mask. He was facing a life sentence. It was a 2-day jury trial. He was found guilty and he was given a 40-year sentence. There was a myriad, almost an unbelievable amount of serious errors that happened in this case that I, as a post-conviction attorney in 25 years, have not seen in any case. The 2 claims that we raised in our post-conviction motion in the circuit court and now raised here on appeal are ineffective assistance of counsel, failing to properly use remedies. Second, when White was misadvised at the moment of his trial as to the sentencing, trial counsel failed to correctly advise him of his sentence or make sure he had time to consider how to plead. And in fact, White was never ready and never left. The first claim I'll address is the ineffective assistance of counsel, where trial counsel deprived White of an impartial jury by failing to properly.
Well, I think you need to be careful how you say that because you keep arguing. It's not prejudice. It's not prejudice. We don't have to show that an actually biased juror sat on the jury. And you're trying to distinguish from the cases where a lawyer fails to strike someone. Here, it's like a lawyer trying, but something happened. Right.
It's kind of unbelievable. So, and I am being careful. I carefully said White was deprived of an impartial jury when he failed, when counsel failed. And I said that carefully because our Supreme Court has been very clear about it. You have a constitutional right to an impartial jury, and it's effectually by 2 equal cause and remedy. And both of them are done. Busby Court called it our ancient tradition of rendering challenges.
Let me ask you this, because what's troubling about that, I get how you're trying to skin the onion, which is to say, we don't need to look at the case law that basically says, getting a juror on that you maybe didn't want to isn't necessarily rise to the level of prejudice on Strickland, because you're going to have to show prejudice. I mean, you're going to have to show that specific juror was biased. And you can't do that. So the way you're trying to skin this is to say, no, this is a constitutional deprivation of the impartial jury qua jury because of a failure to exercise what everybody wanted to do, which is to exercise the peremptory challenge. The problem with that, what I'm struggling with it is how does a court articulate that rule without that rule swallowing up every single jury selection post-conviction matter? Because that would apply in every case.
That's what I want. And I think we can say that's right. Because I'm reserving that. I did not concede that or use it. I was just trying to be careful. So here's the rule. The rule is this. The reason why in post-conviction it has been very difficult for an appellate court to grant a IAC claim failure to correctly render is because of the evolving nature of jury selection. In jury selection, it really depends, and I've been a trial lawyer, it really depends on who's remaining, what I think of the panel that's there, what I think of the jurors that are sitting. And what this court is struggling with on appeal is in a cause challenge, IAC cause, you can look at the jurors' responses and make a decision. But for remedies, when somebody raises an IAC, my trial counsel should have used it for remedy. You're faced with a very difficult deficient performance problem. How are we going to judge that? And of course, it always comes about accountability. Right? Now, our case is different. So here's the rule. It's an easy one. It will not swallow anything. It's the bizarre case that we have in front of us, where trial counsel wanted to use remedy. We're not trying to decide, should trial counsel have used remedy? I think in Nelson you say, that's a hard one. We can't do that. We can't make that decision because of the dynamic nature of jury selection. But this one is different. If you have 100 members,
What I was going to, I don't mean to cut you off in there, but I get the gist of what you're saying, which is you write the opinion to say under the unique facts and circumstances of this one particular, very curious, strange, failure, to exercise what apparently was the intent, exercise apparently on juror number 15. Based on that, we reverse remand. The difficulty with that is I've not been doing this job as long as my colleagues here, but I have been doing it long enough to see how the law tends to treat those. This is a special case opinions, or this is a one-off opinion. If magic words start appearing, this is akin to, or this is likened, we can liken this to that situation. And next thing you know, we have a free roving prejudice baked into the common law. Whenever there's a failure on jury selection, that's my concern. So I get where you're coming from. I'm not sure though that's.
I hear you. So let me tell you another thing. On direct, you treat the two issues together. Right? So rather like the partial jury, the two complementing mechanisms are cause and remedy. And Busby says they're equal. You use them both to get the partial jury. On direct appeal, you treat them equally. You never inquire on prejudice. If on direct appeal, a defendant has been denied a peremptory improperly, you don't inquire about it. You just reverse the same as for call.
Let's assume that the lawyer did make a mistake and tried to exercise the peremptory and reverse instruction. Don't you still have to have a showing of bias on the part of the juror that ended up on the panel?
No, Your Honor. I understand what you're saying, but here is a distinction of art. We're saying the right to an impartial jury is effectuated by two different but very complementary mechanisms. One is the cause challenge, which is, and you must show bias. The second is peremptory. Why do we have peremptories? Because we have an ancient tradition of honoring and valuing the fact that it can be very difficult to suss out every bias in the jury. And so Florida has embraced the peremptory challenge as an equal way of effectuating your constitutional right to impartial jury. And I don't see as a post-conviction attorney, when somebody is going to bring my claim again, how am I going to have a record? The trial counsel says, just recall this, and let me recall two facts where trial counsel has identified a juror who has been a victim of three robberies when the defendant has been a victim. And then he says on the record that he'd like to strike that juror with a peremptory. And the judge simply says, we're not monitoring. And then, and here's the fact that I will be honest with you, I only realized this time. My wife is to trial, he sees that juror. And he
tries.
Yes, and why isn't he allowed to strike the juror? The judge literally says, you have any peremptories? Prosecutors can't do it. No, he doesn't, because they had used this. But White is now charged with a life sentence. He has 10. So the prosecutor was wrong. And the prosecutor stood up and said to the judge, Judge, he has no peremptories left. You can't strike juror Pat who has been a victim of three robberies. But says, sorry, White, sit down. And the prosecutor and White were wrong. He had 10 peremptories, which is basically life sentence. I don't see how I will have this thing. I don't see, I understand the concern of writing opinions that encourage claims that are going to be difficult to decide. I do see how in ineffective systems of a peremptory, you're just not going to be able to suss that out in most cases. You're not going to have a record where trial counsel tried and failed, and then the judge, the prosecutor's decision, failed to strike him as it's not going to happen. I'm going to address the second. If White, that he would have played, and of course, the circuit court ruled against us, saying that it is too speculative for the prejudice analysis. I'm sorry, Judge Kelly, I apologize, but I don't know how much time I have left. So
You're at 9 minutes.
and I'm sorry, On this claim, White, of course, the two facts are intertwined inextricably. That is, why wasn't he arraigned with that? Because White was saying, well, what's that juror doing on my juror who's been a victim of street robbery? And that discussion, somehow, I've never seen it, somebody is not arraigned, and he does it. And before this, he's facing a 15-year sentence. Then he's advised he's facing 30 years, and if I say both were wrong, what I will say is I understand that 16 years is not the case. But our claim is, if White, a bipolar defendant who has never gone got in trouble because of his drug problems, always played. If White had been given the 21, the time that he needed to consider how to take, White would have played. He's never gone to trouble. He knew the evidence was strong, and he would have led. And then the question is, the circuit court ruled against us, saying, and the way I read it, you can never show prejudice if you don't have a feeling. But in Florida, through statute, the court must give a defendant acceptance of responsibility and remorse for pleading guilty. And to say that it's too speculative at a 40-year sentence after a 2-day plea, too speculative that his guilty plea would have provided no lesser sentence. I don't, that has to be ignoring the law. The trial judge would have had to consider if he had acceptance of responsibility. And all we have to show is not a preponderance of that. A reasonable probability that White would receive some sentence. And I think.
Well, but he was facing life, so even if the trial court followed the law, as you indicated, we should presume, what we do, 40 years could be the mitigated sentence.
It could. And the exercise I'm asking you to engage in is one that judges do in every post-conviction, which is to look at the facts and decide is there a reasonable probability you would have gotten.
Well, there's nothing in this record in you declined to plea. Turn down 20, you turn down 16. I recall when you turned the 15 down, you thought he was looking at a possible 30. And everything in here indicates that this defendant was not going to take a plea. He wanted a trial.
I disagree.
If I'm wrong, tell me what indicates that he was inclined ever to plead to this.
So the uncontroverted facts of the entry that he would have led, and here's how.
Controverted in the Senate.
Yeah, and here's that. He's charged initially he's charged with robbery with a gun, and he's facing a life sentence initially. But he knew. So when he got a plea offer, knew that the plea offer he had gotten initially was they're going to discover it's a gun. Only he faced it. So he didn't take that. Then they amend his charge, and he's facing a robbery with a maximum.
So are you saying you think you would have pled open? The possible life sentence?
Yes. Versus going to trial. Acceptance of responsibility. The man has never gone to trial before. He testified he would. He never had a reasonable plea offer in light of what he was charged with. But there's no evidence that he wouldn't have, except that he didn't. But he didn't because the original plea offer made no sense. The second plea offer with the maximum was 15 years, basically 15 years. When it was elevated, that's when he never got time.
Let me circle back real quick. Sure. I just want to make sure I understand what you conceded is a kind of unique novel argument on issue 1 about how we should view what the effect of the mess up, if you will, on failing to use the peremptory on juror patent. And am I understanding your argument correctly that we really just don't consider prejudice under the unique facts of this case?
Yes, for the prejudice analysis, would the juror have sat if trial counsel would have had it? So in the impartial jury, whether it's on direct appeal or on post-conviction, the prejudice analysis is, would the juror have sat? And because you don't go into the alternative universe, what would a different there's no court has ever done one. There is a prejudice analysis, but it's what the juror has sat.
Okay, because to my mind, that has to be, because Strickland says there has to be prejudice. So you have to work within that group.
That's right, and so that's what you use for IAC clauses. And
Okay,
that's what you should use.
Let's suppose there was, absolutely was not biased, no question about it, that there wasn't, didn't observe two bank robberies, et cetera, the things that she actually did. Seems like you're saying that that's the end of the inquiry. Because of the fact that the peremptory was botched, it wasn't used effectively, or you get relief.
Yeah, the floodgates are not narrow. It's, they're narrow on the issue. That is, you don't go and question, should trial counsel have used the peremptory? You don't do that. That's what Nelson said. And that's where the floodgates are narrow. In this case, our floodgates are so narrow because you have the definitive evidence. The trial counsel tried to use the peremptory. And the Supreme Court of Florida has said again and again, jury selection, so individualistic, so dynamically going to defer to trial counsel.
Okay, I just want to go back to Judge Black's questions. I'm not sure I understood your answer. It's really responsive to the question. Take out the fact that this woman, who's going to be a juror in a robbery trial, had been the victim of 2, 3 robberies. How you want to look at that? Suppose they just, for whatever reason, she was a school teacher and the lawyer wanted to exercise a preemptory strike and he botched it. Okay, so this juror actually sat on the jury.
Answer is yes. It's prejudice, and I'll tell you why it's prejudice.
You're saying it's prejudice merely because they wanted her off and she wasn't off, even if she didn't observe the bank robbery.
That's right. That's right. I don't want to call her a test.
What the lawyer wanted rather than who actually sat on the juror, and that's what I would follow.
I would advise, I agree with us. In BuzzFeed, the court said they were equal on many matters. We equal and lawyer equal. Cause and remedy. And what I feel is underlying this is, might we get attorneys who sandbag, might we get attorneys who, but how are you ever going to see this thing again? We're on the record, trial counsel makes clear, I'm going to use my remedy, and then it doesn't follow.
We have a test for that actually biased jurors seated during the trial.
That's good.
Depending on the lawyer. Proper peremptory or not, it's connected to who ended up on the jury.
I would disagree with you, Judge Biden. Speaking again, cause complaints.
So let's run with that. By the lights of your approach, you'll get this weird situation where if a lawyer botches a cause challenge, I want to engage in a cause challenge, we're not there yet, and botches that, you're going to have to show actual bias on the back end of the second prong Strickland test. But if it was a peremptory, if you said, I want to use a peremptory, hold on, we're not there yet. No, just the mere seating of that juror. That is enough to not only implicate the improper performance, but also you just automatically check the box for prejudice because it's baked in. I mean, can you help me work that out?
Yes. First answer is, you're not going to see it. You haven't seen it since. You haven't seen it. There's no case. At least I've got my interns to sort of
there might be after this.
Well, I don't think it's going to be times.
Yeah.
Now, I'm telling you, like that. The Supreme Court. Cannot imagine myself or another going through your selection intended. Right? That's not going to happen. So yes, you have 2 equal ways of ensuring your constitutional right to the court. One is cause, one is remedy. There's a lot of interference, in And certainly.
You're coming out again. Fine, so. Here we are.
Appreciate that, much better than no. Thank you so much, and I'll, report that.
All right. Thank you.
Good morning, Your Honor. Counsel. May it please the court. The post-conviction court properly denied appellant's claim of ineffective assistance. Appellant has not proven that the fundamental fairness or the reliability of the proceedings were compromised. Appellant's claim that juror number 15 served on his jury while she harbored actual bias against him, resulting in his ultimate conviction, is not supported by the record.
Now, I want to stop you right there because I tend to agree with the appellants in their argument in the reply brief that the state really is trying to reframe their argument and has not responded to what they're actually arguing. And I feel like I'm starting down that path. And what I wanted to ask you is if you had, if you had the ability to respond to what's in their reply brief and this notion that the state hasn't actually addressed the argument that they're making.
Sure, absolutely, Your Honor. I understand the counsel making the argument that in order to have a fair and impartial jury under the Sixth Amendment to the Constitution, that an appellant has a right to use the parameters however they would like to use them. However, the Sixth Amendment doesn't guarantee a right to a trial however the appellant wants it to. It guarantees the right to a fair and impartial trial. And so the fairness and impartiality is important when you're analyzing whether this particular juror was actually biased. Now, I'm going to go back to the case law because that's where we're at. You need to have that showing of actual bias to disturb the jury's finding. You don't have that, you don't need Strickland. Strickland requires both the prejudice and the division performance. I know that the trial court didn't actually analyze in its final order the division performance alleged by appellant. However, there's no case law to support what appellant says, that you have an automatic right to use the peremptories however you want to use them.
Well, actually, no, actually you can. I mean, that is established case. You can use a peremptory however you want, subject, of course, to that.
Sorry, I stated. But the lack of the trial court's usage of a peremptory in a fashion that appellant wants them to at that particular time, if that is not achieved, then that's not enough to disturb the trial court's actual findings. That's what I
The trial court order says that the judge wasn't even convinced that this would be a cause challenge.
That's correct.
So again, back to the idea of, it seems to me you have to show something more than just they wanted this to go off. It comes down to who was the result of that. If they're still going to the actual bias test, if there's no bias, then the fact that they botched the peremptory doesn't really matter.
That's correct. Absolutely. Because we want a finality to our judicial system. And without that finality, then we don't have the ability to rest on the decisions of the jury, the decisions of the court. And that's why that Strickland burden is so high. That's why Caratelli requires so much in terms of the actual showing of actual bias.
Walk me through and I'm just not remembering off the top of my head, what were the court's findings and what would a record support for the lack of bias in this case? Because since it seems that was where the judge hung the hat on.
So the juror that was in question, juror number 15, Ms. Patton, she indicated that she was a bank teller and that her bank had been the subject of 3 robberies. She had been there for 2 of the robberies. One of them was simple and one of them was armed. She indicated that it occurred a while back. And when asked by the prosecutor whether that would affect her ability to judge the case fairly and impartially, she said, no, I don't think so. That record does not show any actual bias. That record shows an individual who can put their personal experiences aside and say, well, what I'm going to judge with these fair.
You know, I had a little bit of a feeling of, catch-22 here when I read this, because the lawyers thought, he's not worried about that. He's going to use his peremptory. So I'm not going to, beat this woman up and try to cause. I'm just going to use peremptory. But then he doesn't. So, well, then I don't have all the questions. and answers that would either show bias or not show bias, because I just thought I was gonna use my peremptory. Yeah, so, you know, doesn't the fact that he didn't use his peremptory and therefore didn't establish his prejudice record, doesn't that play into this at all?
I don't think it does. I think based on the case law, you've got a clear showing that somebody is not, partial. And so,
Where you're showing is, and if I understood that that was the complete response, it was her, you know, the one question and the one answer, no, I don't think so. That's it. That's all we've got in this record to establish either there is prejudice or there wasn't prejudice by having this, or excuse me, there was bias or wasn't bias by having this juror sat on this jury. That's it. That's what we're.
I think you can take a look too at her phrasing and her answering the question.
Yeah, but you can go to the judge's record. The judge's order indicating that he didn't protect, bias.
That's correct.
Well, you get a chance to observe her and have a citizen. The record supports his finding.
He did. Well, and to look at the fact that when she was describing her personal experience with the robberies, she indicated it was a while back.
Well, let me ask you my question differently. If you know you're gonna strike this juror with a peremptory challenge, why would you ask any question?
To try and get that cause challenge so that you can try and save your peremptories for other individuals who want on the jury. I'm looking at point 2, Your Honors. Additionally, the substantial competent evidence presented by the state during the evidentiary hearing illustrated that appellant could not have been prejudiced by the court's mistaken belief about the maximum length of sentence, because there was no offer left to accept just prior to trial on May 27, 2015. There's no evidence to suggest that an open plea by appellant would have resulted in a sentence below that which he received. Without this showing, the post-conviction court did not have the authority to disturb the findings of the jury and the sentence of the trial court. Appellant cannot prove the deficient performance and prejudice necessary to invalidate the ultimate jury verdict because there were no offers on the table when appellant went to jury trial on May 27th. The state's 15-year wraparound offer expired by noon on May 1st, and no other offer was extended at that time. Thus, counsel's failure to correct the trial court did not result in appellant's failure to accept an offer, thereby prejudicing the reliability of the trial results.
Well, it just seemed like the state was trying to get in the plea because it made this 15-year offer, and when he didn't accept it meant the information to charge him with something that would get him a life sentence.
Yes, Your Honor, and
Like, oh, 15 years, oh, now we're gonna charge you and with a sentence punishable by life.
yes, Your Honor. But I think the record is equally clear that appellant did not wish to take any kind of offer whatsoever. What's interesting is that when
I don't think it's that clear because he did, he didn't know they did this. He didn't have an opportunity to even plead. He wasn't arraigned in the new information. Didn't have an opportunity to plead. So I think it's an inference you could draw from this record, but I don't know if it's crystal clear under the circumstance. Anyway, sorry. Go ahead.
Yes, Your Honor. In looking at the record, there are several email communications between the attorneys that indicate, the state attorney from that is trying to get an offer out there that's acceptable to appellant. Appellant's counsel consistently says he's not interested in that, he doesn't want that. And I believe that was also the testimony reflected by Mr. Eisenberg during the evidentiary hearing, that he was scorched earth, did not want anything, he wanted to go to trial. And if we're looking at the potential prejudice that's argued by appellant, he had a better understanding of his maximum exposure than anybody else in the courtroom at that time. Because you have him come in, he sees the juror, he then asks to represent himself, he does a Brett inquiry. During that Brett inquiry, up and down, he's repeatedly saying the phrase PBL, meaning punishable by life. So I believe that he had a better understanding of his exposure than anybody else in the courtroom. If you look at the record, it's not your defendant who's not engaged, who's not taking notes, this is an appellant who's very much so involved in his defense. And so I think that the record reflects that he got to the trial day of, he decided that he wanted to move forward. And that, you know, it's buyer's remorse, unfortunately, after he received that 4-year sentence, after the jury found him guilty.
I'm remembering something else. Didn't he give his lawyer a list of like 30 things he wanted to follow up on that? That was after the 16-year old was convicted.
The jury,
That's right.
just before trial.
Indicating, in other words, he was not really inclined to plead, he was trying to investigate, not defense.
He was still in the investigative stage and did not wish to move forward, with a plea to resolve the case. The only option available to appellant at that time would have been a plea to the open court. There's nothing in the record to suggest that appellant was prejudiced because his exposure was the same at that time. Even if it's 60 years, even if he believed at that time it was 60 years and that was his exposure, 60 years is equivalent to a life sentence for an individual in their early years. So if he had the expectation that he would die in prison and he received the maximum sentence, regardless of the actual number stated by the court, appellant experienced no prejudice towards this court in the jury findings. If there are no other questions, I would ask that you affirm the lower court's denial of appellant's post-conviction motion for relief, and we stand on the arguments. Thank you so much.
First issue is that there is no actual findings because the circuit court did not hold the evidentiary findings, and that judge is not the judge. Recall that on May 20th, the jury selection of the division, May 26th, 27th, Judge Cobb said. So when the juror claim is eventually raised, this was part of the conclusion when the wife showed up. The judge said, Judge Cobb had made no observation. Not referring to any factual findings. There were no factual findings. This claim was dismissed as one file. In fact, a couple of cases in the meeting robbery. Listen, I'm focusing on Frankie, but our cause claim is not very different from meeting robbery. In meeting, basically the juror said, I've been a victim of a robbery with a gun, and after questioning said, I can be unbiased. Still, this court overturned. In Rodriguez, it was very similar. So our finding is not far off, but I'm focusing on the and the fact that it should go back because we don't have any factual findings.
Okay, I'm still hung up on the prejudice analysis. My argument that the prejudice is whether a juror that should have been struck actually sat on the jury.
That's right.
Okay, and yes, a juror that should have been struck, that they wanted to strike, sat on the jury, but then not to sound facetious, but so what?
So what? You concrete right in partial, which is effectuated by. Again, this is from Busby and also Smith versus State from the two cases over says that your right to a concentrated and partial is effectuated by equal mechanisms. Equal. They don't say cause is more important than parameters, it's cause and parameters. And we're going to go on direct.
So are you saying the prejudice is you were deprived of the constitutional right to a peremptory challenge to having? I mean, I don't.
You were, but Judge Kelly is exactly what you have done again and again on record. I'm not asking you anything different on direct appeal. If a judge denies you peremptory improperly, how's that happen? The judge says, well, you're not allowed to use that because the guy's a jury. Well, that wasn't a reasonable denial of peremptory. This court reversed for a new trial. The guy went to trial. This court reversed. So this court does it again and again on direct.
Yeah, but we're here obviously in a different posture.
That's right. But the idea that you were reversed and for a new trial, simply because a juror who shouldn't have sat as a peremptory sat, is not a new idea. You would only come on direct appeal. And the only stretch that I'm asking to make here is that
It's kind of different.
that's That's what I'm addressing. The only stretch that I'm asking you to make is that for deficient performance, for the performance reason, you have found that it's too hard to figure out when an attorney should or shouldn't be referring. It's easier to.
How do we know that the juror was biased? There's nothing in the record to indicate, you're suggesting that because of the fact that she observed these two robberies, that we should automatically conclude that she's biased. There's nothing in this record.
Just like you're stating again, the cause related to my further challenge, I'm not asking you to find me biased. However,
So that's the test.
well,
For conviction, that's the test.
yes.
Is there actual bias? There's nothing to indicate, unless we conclude that based on the facts, as we see them, that it's sort of, no,
Well, let me, and I'm gonna use up the last of your time. Sorry.
Can I do that? Before I do, I have to do a factual correction.
Okay, go ahead.
So when, my wife was staying at trial, I was facing life and my attorney, we were trying to, the original charge with robbery. He was facing life. His attorney had many failures. That's what he was referring to. He wasn't saying, he wasn't acknowledging that at the time he was pleading, he thought he was facing life. That has been corrected in the record again and again. He just got raised again. That's a mistake. I
Okay,
never thought he was facing.
I really want to ask this last question. So is your argument, is it a fair characterization of your argument that in this situation, the fact that the juror sat, prejudice is whether the juror was biased is not a relevant question,
That's
regardless of bias. You get a juror that should have been peremptorily taken out, actually sit on the jury. We don't even go to whether that juror was biased. It's immaterial.
remember.
Okay, we're out of time. All right, thank you. Interesting argument. Thank you both. All right, our second case this morning, SS versus the Board of Sarasota County.